We try to be prompt in this committee, and I want to apologize to everyone for running late. We had to wait on some members to get here from other meetings for a quorum, but we'll begin now. Let me a couple of housekeeping matters before we get started. I'm going to make some subcommittee assignments because I know the subcommittees are planning to meet at least once each, if not more often, next week. House Bill 52 will go to Subcommittee 2. That's the Mumford Subcommittee. House Bill 308 will go to Subcommittee 2. House Bill 314 will go to Subcommittee 1. House Bill 316 will go to Subcommittee 2. House Bill 334 goes to Subcommittee 2. House Bill 394 will go to Subcommittee 2. No, I'm sorry, that was a 1. That goes to Subcommittee 1. 394 by Representative Lunsford goes to Subcommittee 1, the Knox Subcommittee. As does House Bill 395. That will go to the Knox Subcommittee number 1. And House Bill 397 will go to Subcommittee 2, the Mumford Subcommittee. We had, I think, 3 bills on the agenda today. Is that correct? I got mine here. Let me make an announcement about one of those. House Bill 50 by Chairman Forster. We needed to make a minor improvement to, and so I'm not postponing that. I'm just setting it to a date certain, and that will be on the agenda for next Wednesday's meeting. That's the 21st, I think, of February. Is that right? So that one is being added to that, or being put on the agenda for that day now.
Yes, sir. Out of the subcommittee, the substitute, there were some definitions as far as states and countries, and apparently there was a later draft of the international portion that we didn't have in the substitute, and that'll be updated and built in. Thanks, sir.
And I appreciate your good work on that too.
Yes, sir.
Thank you, Representative or Chairman Forster. So that one will come off today's calendar. And the final thing I have to take up is scheduling. Under the adjournment resolution that we're now operating under, we are not in session on Monday the 19th, nor are we in the following Friday of next week, which leaves us with 3 session days for next week. I'm not sure, and that schedule shorts this committee by 1 in the normal rotation. We will be meeting next Wednesday afternoon, and we'll get out announcements on that meeting, and we will also meet probably Thursday afternoon because we do need to have 2 meetings next week. But we'll get you an announcement on that. But we're going to have to pick a day that we're not using now, given that we're losing Mondays. And I don't want to meet this coming Monday because it's a federal holiday. And I grew up honoring the birthday of Abraham Lincoln and George Washington, so I'm going to honor that again Monday. Okay, we'll take up first House Bill 233, and for that I'm going to ask Meg Heap to come around. I'll introduce her, and then I'll turn the chair over to my Vice Chairman, Robbie Mumford. Meg Heap is an assistant district attorney with the district attorney's office. Please sit here. I was going to come out there, but I'm going to sit here.
Okay.
But she's an assistant district attorney with the district attorney's office in Chatham County, and is involved with, or I guess head of, the only elder law special prosecution unit in the state, and I credit her with the inspiration for House Bill 233. And with that, I yield the chair to Vice Chairman Mumford.
Thank you, Chairman. Ms. Heath, you go ahead and just explain. You'll let her explain.
Let me briefly just introduce the bill, if I could, and then she will be the main show. And I know others are here to speak, I think, on that. Thank you, Mr. Chairman. House Bill 233 makes a simple, but I think a very necessary improvement to our law, which enables us to better protect disabled people and elderly people from abuse. Right now, the current statute criminalizes the word exploitation. Whatever conduct is deemed by the court to constitute exploitation is criminalized. This bill simply adds ways by which the court can consider that these vulnerable people, and often lonely people, have been exploited through undue influence, coercion, harassment, duress, deception, false representation, false pretenses, and other similar means. The thinking being that this will enable prosecutors, and we hope there are more of these units around the state in the near future, to get into evidence things that are, I think, very, very material and very relevant when considering these cases. And I think that it is a very, I think it's a necessary piece of legislation to protect our elderly and disabled individuals. And coming from someone that's out there in the trenches taking care of these people. So, Mr. Chairman, with your permission, I'd like to have you recognize Ms. Heap now to tell us about the problem, about what this bill is designed to do, maybe a little bit about what she does.
Thank you, Ms. Heath. Thanks for coming today, and we'll be glad to hear from you.
Thank you very much. Good afternoon. It's been about a year. My boss, the District Attorney Spencer Lawton, went to our commission and got some funding so we could have someone assigned to prosecute elder abuse and those who are disabled. One of the things I've learned, I've relied heavily on this statute to prosecute those, and there's three parts. You can either abuse our elderly, who are those over the age of 65, or anyone who is mentally or physically disabled, and that is through abuse, neglect, or exploitation. And I have relied heavily on this during the past year, and there's two things that I've noticed, the areas that I would ask y'all to help me in changing. The one is just technical. In the statute, it said it's unlawful to exploit, neglect, or abuse. But if you go to the front on the definitions for the chapter, it says exploitation. I would like that the wording would be the same in construction, so no one would be able to argue. So it would just say exploitation, just like the definition does. The second part is, Chairman Ralston had said, it's just a defining the means by which the crime is committed. In terms of the undue influence, I've had several cases I've already that have come through the works in the criminal justice system where these are the means that people have used to prey on our elderly. And I do appreciate Chairman Ralston sponsoring this bill, and I think it just strengthens the bill, and it gives me a better tool once it's refined so I can prosecute those people who do that. If y'all have any questions, I would be more than happy to answer them at this time.
Are there any questions from any members of the committee? Representative Seltzer. Setzler.
Thank you, Mr. Chairman. I just want to ask some questions, if I could, just out of an abundance of caution, and
Sure.
just kind of go through some hypotheticals. Just trying to get my mind around if this in any way opens a door for say you've got a senior that's maybe in the early 70s, late 60s, still basically self-sufficient,
Yes.
still making decisions for themselves, still making financial decisions, decisions to take out credit cards or pay off debt, or, in the whole array of decisions folks make, can make those decisions for themselves. Would we be opening the door for a challenge by, say, the children of somebody to say, hey, I think this meets this new definition of exploitation because we think it was a false representation or false pretense. I mean, are we opening the door to say, hey, you sold this insurance policy or this financial product to my parent, and they didn't really understand what you were saying? Yeah, it's complex, but they're smart people. If you'd really explained it, they could have understood it and not made a purchase which led to a loss. I mean, I'm just asking an honest question. Are we opening the door for that?
I don't think so, because I think the investigation by law enforcement will be the same. I mean, I would still have to prove that there was false representation, and an investigator, a law enforcement officer, would not only take into account and speak to the victim in the case, and if they've made a decision on that, was based on facts and what they chose, we're not going to. It doesn't open it anymore. It just gives us another way to prove the crime. If we find there's a couple different avenues. And this is under the section where if we felt there was an issue of someone's competency, Adult Protective Services could get involved and determine whether this person was competent to make those decisions. But for prosecution, I think it still goes back that I would have to prove the crime the same way, and law enforcement would have to collect all the facts and collect pieces of evidence that would in fact show that the person was unduly influenced into making this decision. Does that answer your question?
It's starting to, but I guess the question is, do we create a new, do we create a requirement now for an insurance agent or a stockbroker to make a determination of the competency of this senior citizen? They're over the age of 65. And I don't frankly know how that plays out now.
I think the law by itself already, the exploitation is already there. This is just refining it. There are, just in this statute, there are mandated reporters if they feel that there's something going on that should set up a red flag, but I don't think it puts any more pressure other than what the law already has there in terms of if somebody comes in changing their banking habits. The banking community is already a mandated reporter, so they are already aware of what they should be looking for if someone is being unduly influenced. I don't think it puts any more pressure or mandates anymore. I think that's already there.
All right. Did you have a question?
I did. Okay, thank you.
Thank you. Just make sure that all this is misdemeanor. That's correct.
No, that's not correct. Elder abuse is a felony. It's 1 to 5 years.
Okay, so we're on line 20 where it says shall be unlawful. And what we call that is back.
That is correct.
Our chairman. Did you have-
I did have a comment because I think Representative Setzler raised a good point. I've litigated some of these cases on the civil side, and I can tell you that they're heartbreaking cases because they're cases that involve people who are preying on very vulnerable people and very lonely people, quite frankly, most of the time. But I wanted I know your concern, and I think it is valid, and I wanted just to answer your concern, if I could, by talking about the concept of undue influence. Undue influence in the law is a fairly high standard to meet. Mm-hmm. You have to prove that the perpetrator, I guess in this case, has literally acted in such a way that you have substituted the will of that person for the will of the victim. So it's a pretty tough concept to prove. It's not divorced altogether from competency, but it you can have that with a competent person. Mm-hmm. But it's a high threshold.
All right. Representative Abdul Salam.
Thank you, Mr. Chairman. I first of all would just say thank you for bringing this bill. I guess my many adult years, I've taken care of several, and taken care of a 95-year-old and a 68-year-old that's disabled right now. But in doing that, I've experienced some personal challenges, and I'm just wondering how this would address a situation that we're facing now. And that is, what I'm not clear about in the law is if these persons are in a facility, adult daycare or assisted living or nursing home facility, where does the criminal process start? And I ask that because we have clear-cut violations. They've been written up by the state investigator. However, the director of the facility must take out charges with the local sheriff and won't do it. So I'm saying, I'm glad for this, but I don't see the process for enforcement, I guess, is
In the long-term care facilities?
yeah.
Okay.
Short-term, too, I mean.
Now, the way I'm seeing it work for us is that the Office of Regulatory Services are called in to investigate
Okay.
if they believe that something has occurred, and those agents are then coming to me with files and saying, okay, do you have it? Is there anything we can go forward on it? And I have received some in the last couple of months, or the GBI has been called in to investigate, and they turn over files for me then to look at and see if I can prosecute it.
And not to just do my personal thing, but I need answers. We were told that we could not file those charges, that the director has to do it. So I guess what I'm looking for help on is how do we overcome that issue?
Now, I'm not sure how that works. I mean,
we're talking about criminal issues and the undue influence is definitely there. This person is basically living at the nursing home, basically controlling visits and visitors, stealing medication, all kinds of illegal things. However, because the director of the facility does not file a police complaint, because I guess she is the authority.
right. I would think you would be able to contact either the Office of Regulatory Services, and they would tell you the steps that you need to take to see if, and they should be able to start an investigation, and also the Ombudsman program, as well as that's another person who can link you up with Office of Regulatory Services.
Thank you.
And they should, it's my understanding, they have their posters, they're mandated to have them in all nursing homes. The Ombudsman, you can call them and they can link you up to the appropriate authorities.
Thank you.
You're welcome.
All right, are there any other questions or comments for Ms. Heath? Thank you very much.
Thank you.
Calling on some other very good stuff to sign. Kim Raymond, you had signed up, Senior Citizen Advocacy Project.
Good afternoon. I'm with the Senior Citizens Advocacy Project, which is sponsored by the Georgia Gerontology Society and the 12 area agencies on aging. We thank the chairman for bringing the bill. We feel that it is a very, very important bill. Anything that goes to expand that definition of exploitation for our seniors and our disabled individuals in the state of Georgia is very, very important, because there is a lot of financial exploitation that goes on, and we feel that this bill will go a long way to help curing some of those problems that we have out there. So we do ask for your favorable consideration of the bill, and we thank you very much for listening to us today.
Thank you very much, Ms. Raymond. One moment. Are there any questions for Ms. Raymond? I don't see any. Thank you very much.
Thank you.
Is it Melanie McNeil? Can't read your writing.
Right, sorry. Hi, I'm Melanie McNeil. I'm on staff with the Georgia Council on Aging. Ordinarily, our legislative counsel, Ellen Williams, would testify on behalf of the council, but she's not able to be here today. And that council has, over the years, supported legislation that would intervene or prevent elder abuse, exploitation, and neglect for seniors, and we're supportive of the bill and appreciate the chairman bringing the bill today and ask for your favorable consideration. Thank you.
Any questions for this witness? I don't see any. Thank you. Becky Kurtz.
Thank you, Mr. Chairman. Good afternoon. My name is Becky Kurtz, and I'm the State Long-Term Care Ombudsman. First of all, since the program was mentioned before, let me say to Representative Abdul Salam, I'm happy to get in touch with you. I've got my card to give you. We advocate for people who live in long-term care facilities, nursing homes, personal care homes, sometimes also called assisted living facilities. And we have been very supportive of this legislation, very grateful the Chairman has brought this issue forward. We think it's very important. I thought it might be helpful to this committee. I took a look at some of the data that we receive in the Ombudsman program on the long-term care facility side of things. We don't deal with the community side, which Title 30 deals with in this bill, but the Title 31 piece of this bill is Long-Term Care Facility Abuse Reporting Act. And I thought you might find it interesting to know that last year, in state fiscal year 06, we received 89 complaints related to exploitation of individuals living in long-term care facilities across the state of Georgia. Thought you also might find it interesting to know that of those, only 7 were related to someone employed by or affiliated with the facility. The 82 others were related to either a family member or a third party from the outside in some way exploiting that individual. So I thought those numbers might be helpful so you'd have a sense of what we are seeing in facilities, at least, not the community side of things, where I think that actually the numbers are quite higher, but at least on the facility side of things. Be happy to take any questions if you have any.
Questions?
I do have a question.
All right. Go ahead.
Thank you for being here. I have an interest in this. My mother actually worked for Legacy Link in Gainesville for 25 years, and the Ombudsman program has been lacking. What would you describe that program now in regard to this and helping enforce what we're hearing? How is your staffing? I know that was an issue at one point. Those kind of things like that.
In terms of our resources?
Yes.
Well, let me just say that we always are struggling for adequate resources, as many agencies are. But let me also say that we don't do, I just wanted to clarify something, we don't do the enforcement side of this. We are advocates for the individuals, and if the individuals want help knowing how to get to enforcement, whether that's law enforcement or whether that's to the Office of Regulatory Services that enforces rules and regulations, or whether they want to go a civil litigation route or a whole other route entirely, we help them navigate the system. So, but thank you for your friendly question. We can always use your support.
You do good work, and I appreciate it.
Thank you so much.
Any other questions for this witness? I don't see any. Is there a motion at this time? Entertain one. For Abdul Salam, who's what? Who passed? Who passed? All right, there's a second. Mr. Lunsford, second. All those in favor, raise your right hand. It seems to pass unanimously. Back to the chair.
Actually, I'm going to turn it back to you momentarily, but yeah, this one's mine too. But first of all,
How come you got on front of everything?
I'm taking care of my business so we can get out of session early. We wish. I neglected earlier, and I am very, very sorry in doing so, because a friend of mine is here today as Judge of the Day, and I want to recognize Judge Al Wong from the State Court of DeKalb County. We're honored to have you, sir. I just feel better with you in the room, Judge Wong.
I'll just sit here and be quiet.
Okay, we're going to now take up House Bill 270, and I will yield the chair once again to Vice Chairman Mumford.
This is the Juvenile Proceedings Appointment of Guardian Ad Litem Bill dealing with CASA's. Ask the author to give us a brief synopsis of the bill.
If I could have Wendy, would you come up, please? You didn't sign up. Add her. Do we have, okay, we got everybody we need up here?
Yes, sir.
Okay. Thank you, Mr. Chairman. House Bill 270 is a little cleanup bill that was brought by, or on behalf of, I should say, the CASAs, or the Court-Appointed Special Advocates in Georgia, who represent juveniles in deprivation proceedings in our juvenile courts. This bill came about as a result of a task force that the CASA leadership put together, consisting of attorneys and judges and program directors and advocates around the state. They looked at what other states are doing with their CASA programs. They worked with a number of departments and agencies here in Georgia: DHR, DJJ, DOE, the Council of Juvenile Court Judges, the Office of the Child Advocate, Children's Health Care of Atlanta, and many other advocacy organizations involved with issues important to children. And have come up with this bill, which you have in today as a committee sub. And what is the number? 27. judynon21407. And it's designed to bring some stability and uniformity to how CASAs are incorporated into the juvenile court process in these type of cases around the state. I think this is an excellent program. I think this bill improves the law in that area, and with your permission, Mr. Chair, I would ask Wendy Clifton to sort of take us through this and tell us why it's needed and what the bill does.
Thank you, Mr. Chairman. Call on Ms. Clifton.
Thank you, Mr. Chairman. It's a pleasure to be here today, and I have with me two staff members with Georgia CASA. Our executive director is Dwayne Hathaway, and then Angela Tanzella is our lawyer on the Georgia CASA staff. And I'll let them answer any specific examples if you have questions about any specific examples or any technical issues that I may not know the answer to. But the gist of what Chairman Ralston explained as to the reason for this legislation is very simply clarification and uniformity. There are currently, and I'll be happy, I don't know if I have exactly enough, but I think I have quite a few of these, and if not, we can certainly get a couple more, but I'd be happy to pass this around. This is just a one-pager that shows you where all the CASA language currently resides. CASA language resides in the national CASA standards, which Georgia signs off on those, and we accept all of those. CASA guidelines reside in the juvenile court bench book. CASA guidelines reside in DFAC's protocol, but there's no one location where a new CASA program or a new juvenile court judge can go and find out all the things about how a CASA is supposed to behave and what they're supposed to do, what their roles and responsibilities are. In doing this research and in working with the task force, Angela determined that there were 37 other states that have their CASA in the code in pretty significant detail. And there were some CASAs that we found in other states that are exceptionally more detailed than what we're proposing. So we went from a 10-page bill originally down to what you see today, which is fairly short and brief and to the point, which were the things that we felt were most important to help CASAs in Georgia operate in a streamlined, uniform, and clear fashion. And so that's what you see before you. I'm happy to go through the bill section by section, Mr. Chairman, if that's what you would like for me to do. Would that be in order?
That'd probably be a good idea. Try and get through it as quickly as
okay.
you can.
Section 1, this is where CASA is already in the code in Georgia, and it's the only language in the code about CASA in terms of what the role is supposed to be. We would be just basically taking this language that is currently in Section A, 1511.9a, and adding a lot of things to it in 1511.9.1. But in Section A of 9.1, you see those are our definitions. The first one, defines what a CASA is and then goes through the criteria they have to meet in order to be a CASA. And then 2 is what an affiliate program is. Throughout Georgia, we have 44 of the 49 judicial circuits currently have CASA programs. And you have to be an affiliate program in order to call yourself a court-appointed special advocate in Georgia. And so that's why the definition of an affiliate program is in here. Section B, they are required to complete specific program requirements. In other words, you can't just walk in off the street and say, I'm here to volunteer to be a CASA without having gone through the rigorous training that Georgia CASAs are required to go through. There are many reasons for that, but primarily it's so that they follow the procedure, but it's also so that they understand their sole role is to represent the child's best interest. They're not there to represent either party. They're not there to represent themselves. They're there to represent the child's best interest, and that's a heavy part of their training that they go through. Section C specifically states what the role of a CASA is. All of those criteria are set forth in national CASA standards and in Georgia CASA standards. And so these really aren't, I guess, in the big scheme of things, if you're going to be a CASA, these things aren't negotiable, if it were. I mean, in other words, you can't make the decision as a CASA in a court, oh, well, I'm not going to do number 7 because I just don't think it's appropriate. You're not allowed to do that. That's the whole point in going through the training and being a member of an affiliate CASA program. Section E, as a lay guardian ad litem, a CASA shall not be required to, I'm sorry. Okay. Shall not be required to engage in activities construed as the practice of law. CASAs are not lawyers. They can be, but they are not lawyers. They are not there practicing law. They are there to serve as a volunteer to the juvenile court to look at the situation and give a recommendation back to the juvenile court judge of what's in the best interest of the child. Section 5 relates to notification. In this particular area, what we're talking about here is one of the challenges in trying to draft this legislation is that courts and DFACS offices and law enforcement and all the parties that are involved in DFACS deprivation cases in local jurisdictions, they all do things differently, and we recognize that. And so a lot of the language you'll see in this bill is intended to be flexible. We are not trying to nail down every single finite detail in order to have a local jurisdiction potentially scream and holler that we're not going to do it this way. And so some of this, so this is a particular area, notification, which we've been talking about a lot with a lot of different folks. But this notice is around specifically the issue that there are occasions where CASAs don't get notified of a hearing that's coming up. And it's not on purpose, and we know that, but occasionally a juvenile court judge who has appointed that CASA will not get notice from the clerk. And it's not that the juvenile court judge didn't want them to get notice, it was just an oversight. So this is more of an opportunity for us to streamline that process and ask that the CASA be notified just as the parties are at the request of the juvenile court judge. Section G is around the issue of access to records. When a CASA is appointed currently, as without the law today, when a CASA is appointed in a Georgia juvenile court, they are given a appointment order, and they then present that appointment order to a school, to a DFACS office, to a hospital where they might have treated that child, and are supposed to be given access to those records around that specific deprivation proceeding. There are occasions, however, where a DFACS office refuses to give access, even with the court order. And so this hopefully will give us a little bit more oomph with those particular cases to get them access, even though they already have the court order, that the code will also strengthen that a little bit. Section 8 is confidentiality. All CASAs are required to fulfill confidentiality issues, as would a lawyer, but this is back to the court as opposed to the client in the case of a lawyer. Section I is an immunity clause. We've worked on this language extensively and feel really good about where we are with it. We've worked with the Trial Lawyers Association to get this language crafted so that it is acceptable in their eyes. And then Section J is about removal of a CASA from a case, which we think is appropriate, and it already is the way that removal takes place in juvenile court deprivation proceedings today.
Thank you very much. Are there any questions for Ms. Clifton? Mr. Setzler.
Thank you, Mr. Chairman. Just to educate me a little on the process, in practice, and I know they're appointed by the courts, but who recruits, trains, and prepares CASAs? And I mean, is DFACS in any way associated with that, or is that purely a court function?
It is not a court function. It's an affiliate CASA program function. I'll let Angela explain more in a little bit more detail.
Yes. Okay. If a volunteer is recruited by the CASA program, they might see an ad in their paper, on the TV, at a civic club, and the volunteers come into the program. They are screened. They go through criminal background checks, make sure they're not on the sex offender registries, all sorts of backgrounds. Then the training is 30 hours of in-service training, as well as court observation. All of this has to be done, personal interviews, reference checks, all of that has to be done before a CASA is appointed.
No, administratively, the whole CASA program, the paid staff within the CASA program, are they administratively supported through DFACS or administratively supported through the courts?
The CASA programs are structured 3 ways in Georgia. First way is a nonprofit organization, so they're an independent affiliate, just as the definition says. Then there are about 9 of them that are court programs. In that case, then the CASA staff person is an employee of the court or the county. And then the third way, they're under the administration of an umbrella nonprofit agency that normally has a similar child welfare kind of mission.
And Mr. Chairman, the reason I asked the question is just the idea of independence, and in my mind, to be an advocate for the child that's truly objective and operating in the best interest of the child, it would seem to be there would be some loyalties that were blurred if they were attached to an organization that is in the whose roles and responsibilities might be blurred with respect to DFACs. And I know we've got a lot of great committed DFACs agents out there who are underpaid, overworked, underappreciated. But the concern is, with respect to what's truly in the best interest of the child and representing their interests, if we're going to put this in code, it would seem that the closer we can get the CASA program to administrative support of the courts, even if it's a nonprofit entity that maybe funding flows to the courts, and further away from the DFACs umbrella of agencies, the more independent and the closer to the interest of the child we might be. And that's a concern of mine, is just that, again, even if there's no specific directives that are coming from a DFACs organization, even administrative attachments for funding and providing space and those kinds of, those ties sometimes can kind of lead to some influence into who's recruiting whom, what population of people are you going to recruit for your people who bring their own values and assumptions to the table in representing kids. I'm much more comfortable with the courts than I would be within a DFACs-like structure. And I just want to see if that would be concerned of any other members of the committee, or if you could speak to that.
I just to clarify, I think to Angela's point, the answer to your question is there is no administrative attachment in terms of any of the programming. DHR does provide funding to the state office here in Atlanta, which is then formulaically distributed out through the state, given the program size and how many children are served and how many children are in state custody in that local jurisdiction, et cetera, et cetera. But the local program is not in any way attached to DHR or DFACs in any of the 44 districts or circuits, that we work in.
I guess my question is, and again, this may be something I'll just back off and shut up about, but I mean, ultimately, if funding is coming through DHR, I have some problems with the independence of different echelons of leadership and how that's going to play out to the role they play in advocating for kids. In some cases, saying, I don't think this field agent's did the right thing. I don't think it was in the best interest of this child. They were removed from the family for these reasons. And even though it seems to be somewhat separated, I think, again, funding channels and those kind of things are very significant. And I don't know if we would contemplate making this relationship more closely aligned with the courts. I just am expressing some concern.
Representative Knox, do you have a question?
I guess maybe a response. My observation is that Department of Family and Children's Services, the CASA, the judge, at least 1 or 2 attorneys, there's a whole bunch of folks in there going at it when there's a child involved, and my experience has been that nobody gives anybody any slack on those cases, and you'll probably see CASAs about fighting with DFACs about as much as they do with anybody else. So.
Mr. Levitas.
Going back to section I on page 3, I may have missed this, or subsection or subparagraph, whatever the little I is. What is the reason that we're granting immunity except in cases of fraud or malice?
Sure. Actually, it's in the case of fraud or malice, if you read to the very end of that sentence, as a result of taking or failing to take any action pursuant to this code section.
Right.
So our specific issue is, originally when we drafted this legislation, CASAs, because they are all volunteers, actually fall under a federal volunteer act of receiving this exact same immunity. But because we don't recognize or carry forward in the Georgia Code, federal code, we decided not to put that in here. But so essentially, whether you put it in here or not, because of that federal act, they are already immune. Does that make sense?
It does to me if the federal government has expressed an intent to occupy the field and that their legislation would preempt ours. If that's the case. If it's not, then it doesn't make as much sense to me. And again, I'm not questioning whether or not we should have it. I would like to understand what the policy considerations are behind that.
I'll let Angela address that a little bit more, because the immunity language is in all the other states that have the code sections, and so it was something that we considered. We had extreme amount of debate about it. From a volunteer recruiting perspective, I think the best policy answer is if you don't offer this and you give every deprivation parent that's involved, and they get mad at that CASA for saying, Judge, I recommend that the child be removed from the home, and then that mom or dad can go after that CASA for making that recommendation that they really believe is in the best interest of the child, it would probably completely abolish our ability to recruit volunteers if one of those cases were to happen.
No, and of course you wouldn't be able to do your job of every single decision that you make. That said, fraud and malice, as you know, is an extremely high standard. So I just wondered, are other states, when they implement this, do they use that fraud and malice standard as well?
Actually, the fraud and malice language was inserted by GTLA.
Okay.
And so I'd be happy to defer to them. Because we accepted that language as a friendly amendment from them so that they would be comfortable with the immunity language.
Okay. And my guess is that was to make it not completely immune, that you would have to show fraud or malice, and so...
Yes, that would be my assumption.
Do you know in other states, is there a fraud, and is that something that GTLA is better able to answer?
I know they'd be able to answer about other states as it relates to CASA, but I don't know if in our research did they...
I think they cite fraud and malice, and then anything that's outside the scope of the responsibilities, civil or criminal.
Thank you for your answers.
Sure.
Thank you. All right, Mr. Everson, did I hear you had a question? Sorry.
Yes, page 2, line 20. Beginning with the word circumstance and continuing on, circumstance shall sign an order appointing a CASA at the earliest possible stage of the proceedings. In your opinion, what is the earliest possible stage of a proceeding? When would that occur?
Sure. CASAs are appointed at different stages. At the earliest possible stage would be at the 72-hour hearing, which is really after the children have been removed from their homes. But they can be assigned at the adjudicatory hearing or any point during the case. Obviously, the earlier that a CASA is assigned to the case, the better, because that means the quicker that permanency can be achieved.
Follow-up question, Mr.
Yes.
Chairman. Are you aware of any case where a CASA has not been assigned within 72 hours?
Yes, many. There's been many cases. I was a CASA volunteer for 2 years in my hometown of Macon, and there were both cases that I was assigned to. I was appointed much later in the case after the kids had been in foster care for a considerable length of time.
Yes, Representative Collins.
Yes, I appreciate the opportunity, Mr. Chairman. I appreciate you bringing this bill, because maybe it might address some of the questions, formalizing the process here. The question that I have is concerning the supervision of the actual CASA representatives in the process of dealing with a case. First question is, how is that structured now? Like, when you were assigned a case, who supervised you, and how was that handled?
Okay. Depending on the size of the CASA program, a CASA volunteer will be supervised either by a volunteer coordinator or by the director of the program. It is a national and Georgia CASA standard that a coordinator or director shall carry no more than, shall supervise no more than 30 volunteers or 45 cases if they're a full-time staff person.
A follow-up, Mr. Chairman.
Yes.
Okay. And what was stated just a moment ago in page 2 in section D concerning what they are assigned to do, is this what I would classify as the supervision scope? Are they doing these 1 through 9? And at any point during a case, or is it an ongoing process? Let's say you were assigned X child, and this was a 6-month process. At any time, would you sit down with your supervisor and say, okay, how am I doing on these? What kind of, and then I want to not be, and I don't mean to say that it's not, but reality. You got 30, 40 volunteers doing a lot of different cases. What's the reality of an actual supervision and the quality of that supervision of specific cases?
I would say that the reality is that the staff person is required to make monthly contact with the volunteer to make sure that, depending on where they are in the case, not all of these 9 things may need to be done, every month, but just making sure that they are meeting with the child every 30 days and that their reports are okay and all of that.
Okay.
Go ahead.
And question: if someone who's dealing with the program, let's say from a foster care, a child has been placed in a foster care or protective care situation, what is the process if someone, again, dealing in the best interest of the child, not the person that's been removed, but that other child, what is the process if they were concerned about the level of participation of the CASA representative and its seeming lack of participation? What's the remedy for, or the help in that situation?
At any time, a foster parent, attorney, anyone who's concerned, a DFACS staff person who's concerned that a CASA may not be participating up to par or meeting these things can call the local CASA office, talk to them about that, can talk to the judge, and then a lot of times it's deferred back up to our state office, too, if it's a serious complaint.
Is that in any way made known to these other representatives who are being brought into a case as a helpful? Do they know that they have that ability? The reason I asked, and this is a wonderful program, but I did have some constituent concerns that, to be honest, they felt like they were not getting some of the help, and some of it may be addressed by this bill, and I'm glad it's been addressed in this, because it formalizes more of the status and gives some priority to it. But dealing with volunteers who have lives and everything else, that was my concern, that you get a long, tedious case that can get drawn out and sort of can get lost in the system. So I appreciate your candor and your questions, but that was knowing that there are remedies in case a CASA representative just can't handle it. So I
Sure, and there are local, if I can just say, there are local protocols between DFACS and the court that would outline grievance procedures and how to handle that individually.
Now we're back in DFACS?
Well, I was just saying if it was a DFACS person who was making a complaint about a CASA, just using an example. I'm sorry.
Private citizen in this way. Mr. Chairman, thank you.
Thank you. Are there any other questions for this witness? I don't see any. Thank you very much. I'm going to call on somebody who's been here a while, Judge Sanford Jones. How you doing, Judge? Certainly. You mean we're getting a twofer?
You didn't tell him who you were talking about.
I didn't want her behind me. I wanted her beside me.
Well, we're always glad to have.
Notice I've learned to listen instead of always talking.
May I object, Mr. Chairman?
No, you may not. We're always glad to have Judge Miller. I think she's a juvenile court judge in Eccles County. Is that right? Is that where you're from?
Not unless somebody appointed me and didn't tell me.
Oh, okay. What county is it?
Gwinnett
County.
Yes, Mr. Chairman. Thank you.
All right. Used to be a member of this committee.
Long time ago. It's nice to be back. I miss you all as well. More than you know.
We'll see.
Yeah, that's for sure.
Who's going to start, Judge?
Well, we could, if you don't mind, kind of chime in. First, I've been watching CASA for a long time. There are 116 counties in this state. There's no organization that I deal with in the juvenile justice, and there's a lot of my friends from DFACS and DJJ that sit behind me. There's no one I deal with that I have more confidence in than CASA. CASA volunteers are well trained. They're committed to the heart, from the heart. This is an effort to try to make it uniform throughout the state. Now, Judge Miller and I disagree on how some of the wording should be in this, but the concept of what we've got there is exactly what we need. We need to have uniformity throughout the 116 counties as to how CASA should be used. Now, for example, we talk about when CASA is also a guardian ad litem. Fulton County, I never use them as a guardian ad litem. I have child advocates. But there has to be some uniformity, and I think is that the judge has some issues about the word shall. The main thing I would simply say to all of us is that there are national standards. We want to be in keeping with the national standard to make sure that we're in compliance, and that as we go into each county and do it a little, we have a standard that we can go by as they do it a little different, and it will work different in every county. I assure you, it's just like court systems work different. But I simply was here today to encourage you to please help us pass the bill that would uniformly give direction to CASA throughout the state. Now, she's got some specific points that we will probably need to discuss to make sure that we can come to a conclusion here.
I echo the sentiment. CASA is a wonderful program, and we need it. The reality is we have so many different versions of how children are represented and their best interest is represented to the court throughout the state that we need to be careful, and I ask that you be particularly careful when you pass a bill that is going to have impact in ways you may not have thought in some of the counties. In Gwinnett County, for example, we have staff guardians ad litem. We have 6 lawyers who work for assigned to our 3 judges who are the advocates for the children. We use CASAs on top of that as another layer when we think it's appropriate. My concerns are several. Section 2, might as well start off, page 2, line 25 on my copy. In all cases in which a CASA is assigned, a CASA shall. My suggestion is that that be amended to say, in all cases to which a CASA is assigned, when directed by the court, a CASA shall. Because if you just shall everything, then we have people required to do things in every case when we may not need them to do it because we have another individual. I don't want them filing written reports. I don't want a written report showing up on my desk that may have hearsay. It's ex parte communication. The subjects may never know it happened. They may not have an opportunity to respond. I'm not sure what I'm supposed to do with it. So in my court, I may not want a written report. I may want them to appear at a hearing. I don't want them to request judicial and citizen panel reviews. We have those in my division regularly. I don't want them to ask for another one unless it's necessary. But if you tell them they have to do it, they have to do it. I would suggest that that particular section allow the court to assign certain tasks to the CASAs. Now, in the courts where there are not guardians ad litem, where there are just CASAs, the only advocates, it may be different. But in the hybrid courts like mine, it's going to cause problems rather than necessarily be helpful. Page 3, line 5. That paragraph says, among other things, that the CASA shall be notified in a timely manner of all hearings, reviews, investigations. Are you telling the police that they have to contact a CASA and let them know that mommy is under investigation for trafficking? Are you saying GBI has to tell the CASA there's a wiretap? What do you mean by investigations? And who has to notify? Who is captured in the net of this requirement? Who do you mean to capture? I suggest that perhaps that paragraph end on line 5 after reviews and specify saying judicial reviews and citizen panel reviews, period. I don't know what significant changes in circumstances are. Says who, and who are you mandating to notify them of what is significant? I don't know what you mean by it. And you may want to talk about this part. Line 7, the CASA shall be notified prior to the formulation of, or notified of a formulation of any agreement before it's implemented by the court. There are a number of times where I have a guardian, the parents' lawyers, DFACs may have worked something out. They've got an agreement to let the child go home for Thanksgiving Day, and they come to the bench and say, we've got a consent order, Judge. Can you let the kid go home for the day? This says I can't do that, that we have to go get the CASA, run it by them, get there, give them an opportunity to be heard. Concerned about that. Paragraph G, I think, is one of the biggest problems I've got. Sorry.
Yes, Mr. Knox.
Judge, on that issue,
yes,
you're suggesting that we stop that sentence after. Well, you tell me what your suggestion is. I don't want to tell you.
Are you talking about paragraph 2 or above it? I'm sorry.
Paragraph 2, yes, ma'am. Beginning on line 7, where you suggest. I understand the problem that you're talking about there.
Direct from the court again.
Not being notified prior to implementation. I think the court needs to have the ability to be able to carry these things without undue delay, and I think that's what you're getting at.
In that particular section, yes. I don't.
Okay, what I'm asking, I guess, is I don't have staff. I'm not trying to get you to rewrite the bill.
If you have a suggestion about what we might do in that paragraph to remedy that situation.
I think that the CASAs need to be informed when any case plan has been created prior to the court ordering that the participants adhere to the plan. But every stipulation, every agreement, I think, is overbroad. Case plans I have no problem with. I think the CASAs need to know what the case plan is. And before the court orders it, give the CASA a chance to object, just as the parents can object within 5 days of the filing of the case plan. But when you put very big terms like agreement, stipulation, that cuts out the ability for flexibility on some of the more minor changes.
Go on to G.
Okay, G. That very broad paragraph gives the CASA some very strong power to access to all kinds of record that most people don't get. That says that the CASA can open the DFACS file. Sure. I don't. Guardians ad litem don't get it. DFACS has some confidential information.
Guardians ad litem.
The reporter, the confidential reporter who called DFACS and said, my neighbor's kid is being abused. This says CASA gets it. Guardians don't. Lawyers don't. I don't. I don't know who reported it. And when you start looking at medical records, mental health records of the child's family members, well, what's the family? How broad are we going to define family? Uncle Bobby's staying for the summer, so the CASA takes the order and goes and gets all of his medical records for his entire life without Uncle Bobby knowing, or the court having permission, or a balancing of need for access versus the intrusiveness and the invasion of privacy. I just think these kind of things need to be requested and authorized on a case-by-case basis, not just the broad brush of because you're helping a child, you get everything that has anything to do with anybody in this child's life. And I'm very concerned about that particular paragraph.
And that's, can I speak, Mr. Chairman? Sure. And that's where we kind of have a little bit of disagreement. The wording in there says when a CASA is a guardian ad litem, they serve a different role there. They're assuming the role as a guardian ad litem, and I thought that y'all's law provided that a guardian ad litem should have access to information as any other party in a case. And that's what this is saying, and I think that's appropriate at that time. And where there's a question throughout, I would suggest that instead of the shall, they shall have it at the court's discretion. The court can determine what role they're playing and what level of participation they will take in each case.
Well, I would suggest that you insert in line 11, when authorized by the court, they shall. And I don't know, I may be mistaken. Do guardians ad litem have unfettered access to everybody's medical records without court request? That's not my understanding.
Chairman Knox.
With respect to the records that they have access to, I had some of the same concern when I read this myself, is that shouldn't we have some sort of a threshold for CASAs to have access or to be given access? For instance, I'm not sure that they can be given access to records on a basis that would be superior to, say, an attorney guardian ad litem that you appoint, or to an attorney who represents a parent in the case, or that sort of thing. And it appears that this section may give them a superior right to almost anybody in the trial except the judge.
Well, now this one does say when they are serving as a guardian ad litem, and that's the only place you see that in that bill. And I agree with what you're saying. I'm saying, but for example, in my court, they would never serve as a guardian ad litem. But when there is not a child advocate and they are serving a higher level of representing that child, what I understood the legislation to say is then they are entitled to more information so they can make better calls on that child.
I'm not sure, and I'm not arguing with you. I'm just saying, and a guardian ad litem can't get records that are protected by federal law, for instance, out of the file, even if it's in DFACS file. It doesn't make any difference where it is. You can't go get it. DFACS has a legal authority to go get those records under a different code section than this altogether. But it seems like even if the guardian ad litem doesn't give them the authority under current law, and I doubt whether this law really authorizes them to do that, even though it says that. I'm not sure they could go get that information out of the Department of Family and Children's Services, or go to the psychiatrist's office, for instance, and get records.
Yeah, I think what they're trying to address here, you're 100% right. But whatever right a lawyer that represents the mother, for example, would have access to the records, so would they. They would have equal access to see the same records, and maybe it needs to be worded a little bit different. But that's the intent of what we're trying to do, is to make sure that when they're a guardian ad litem, they have all the information in order to be able to make a good decision.
Representative Knox.
I think, Mr. Chairman, that we might need to do a little work on that to make sure it's clear what we're expecting in this paragraph. Because I'm not sure it's very clear. Yeah. Obviously, you have a different idea about what this allows, and I think I do too. And I'd like for us to give some more consideration on how we could craft that to do what it is that. To give them the tools, we want the CASAs to have the tools to do the things that they need to get done. But I think this may need some further consideration, Mr. Chairman.
All right. Is that a motion?
It is.
Is that a motion for further consideration?
I'll call it a motion for further consideration, at least with respect to that particular paragraph.
All right. Before I recognize you for that motion, Ms. Abrams had her hand up.
I just have a question of clarification from the judge. If you could direct your attention to line 19, to Chairman Knox's concern, it would seem to me that that last line captures what you were stating, essentially that they would not have access to any records to which any other lawyer would not have. So to your point, a guardian, this is when a CASA is acting in the single case of being guardian ad litem, and because they are in that position, this line says that you get access to these records, but only as broadly as any other attorney appointed in the same position would have. Is that correct?
I think that was the intent of what we were trying to do, was to make all parties equally accessible to the records.
And do you think that, do you see this as an appropriate standard for a guardian ad litem to have
absolutely.
in this?
That's the only way we really play fair, but he's 100% right. There are things that folks don't have access to, and it wouldn't hurt if we reworded that to make it very, very clear so there'd be no question about that.
So I guess my question is, that line about, would you be recommending that there be records that an attorney would have access to, but that a CASA guardian ad litem would not have access to? So in that last line, just for my clarification, could you tell me sort of what you see would, not to wordsmith it right now, but I guess I'm not certain of what the difference would be if they're limited to records that an attorney would have access to. So if you read the entire section, if the last line of that section says this is limited by the fact that these records are only accessible to the extent any other attorney would have access, I'm not certain what's the gap in information.
All right. I'm going to recognize Roberta Salon.
Thanks, Mr. Chairman.
And then we need to get back to Chairman Knox's situation.
Thank you. I wanted to ask Judge Miller, in the instance of Gwinnett County having the 6 paid ad litems, any idea how many of our counties have paid ad litems?
I don't know the numbers. I know that we have various combinations throughout the state. Some are staff, some are appointed, some have CASAs and guardians, some have no guardians. I don't have those numbers. I'm sure that the folks that are the proponents of the bill could tell you more of the specific numbers.
Because as you were talking, although I understood the concerns, I just wondered what would be the counties that don't have the luxury of being able to pay ad litems, who rely on the CASAs to do so many things that yours do, to make sure that we don't take out something that they would desperately need.
Well, I'm not proposing to take anything out. What I'm suggesting is that the authority and the discretion as to what role a CASA would play in a given case depends on the court. And
but that's already how it is, and we need to fix that.
Right.
So in our process to fix it, let's not leave out those that may not have that luxury.
Absolutely agree.
All right. Thank you very much. The chair is going to take it that Chairman Knox's motion is in fact a motion to table. I'm going to second that motion, and I want to tell the members, I believe that it's the sense of this committee that we want to pass this bill out. We just want to work on the language and get this shaped up to where some of these issues that I think Judge Miller has brought up, which are important issues and probably need to be worked out. I'm going to ask the committee members to support Knox's motion to table this. We are going to bring this bill back, I believe, about next Wednesday. And at the conclusion of this meeting, I am going to appoint, if we table it, Kevin Levitas, Chairman Knox, Stacey Abrams, and Mr. Lunsford get together to get this language straightened out before next Wednesday. There is a motion and a second on the floor to table this bill for this time. And all those in favor, raise your right hand. My right hand. note that Mr. Lunsford very reluctantly voted.
Mr. Chairman, I was trying to decide whether I voted for that government signed or not.
I'll vote on Lunsford. I recall that you volunteered for this committee, sir.
I did, sir. I'm ecstatic.
All right. So this will be tabled until next Wednesday, which means that that subcommittee needs to probably hang around for a few minutes and talk with Judge Miller and Ms. Clifton. I'm sure that Ms. Clifton and Ms. Miller are probably going to resolve all these matters. All right. Thank you very much.
Thank you.
Thank you, Mr. Chairman. Good to see you.
Ask Judge Jones to be in that discussion.
Yeah, Judge Jones, you need to join in that discussion.
I appreciate that very much, Mr. Chairman.
I'm not quite sure how to take this exception.
Have I got the chair back?
Yes, sir.
My comment is that Judge Miller didn't stay on this committee long enough. Could have used a little more being here. Glad to see you. I think that covers all of the bills we had today. We'll get a meeting notice out. Count on Wednesday afternoon of next week and one other day to be determined. We already have 2 bills now on the agenda for Wednesday. There will be others. Do you know when your subcommittee is meeting?
Diane, is my subcommittee meeting on Wednesday morning, Tuesday morning? Tuesday morning.
We go in session at 1 on Tuesday. What?
At 10.
Okay, the Mumford Subcommittee is meeting Tuesday morning, the 20th of February at 10 a.m. Have you? Wednesday at...
After our main meeting.
So you will not meet prior to our next committee meeting?
We'll meet after the full meeting.
Okay. Okay.
I couldn't make it.
Representative Lunsford.
Chairman Mumford, he realized the rules go down at 11 on Tuesday, so that would be the shortest judiciary meeting we probably had this year, or second.
We have
11 is rules, judiciary 10.
We fully expect we're going to conclude.
Thanks, sir.
Any other business come before the committee? If not, we'll stand adjourned.